I'm not a lawyer, but Jarvis Butts, the 42-year-old Detroit man accused of impregnating and then taking the life of this 13-year-old girl named Neziah Harris, had a court hearing today. So for all the people asking about an update on this case, let me fill you in. Before we dive in, it's worth noting that Jarvis Butts is currently facing charges for more than just Neziah Harris. He at this point has at least 5 open cases, and at the beginning of today's hearing, the judge read off all 5 case numbers.
We're calling cases 24-002-236, 24-006-232, 25-000-218, and lastly 25-000-241. These are all in the matters of People versus Jarvis Butts. I apologize, I believe I missed one. There's also file 25-004-478.
So as you can see, the one ending in 236 is for second-degree criminal conduct for a person under 13. Case ending in 232 is for first and second degree criminal conduct with a person under 13. Then there's case ending in 241. That's for first and second degree for a person under 13. The case ending in 218 is Neziah's case. That includes first degree M. And then the last case the judge read ends in 478, and that's for first and third degree criminal conduct. So there were a few reasons for today's hearing. The first is he was formally arraigned on that last case, the one ending in 478, which basically means they told him his charges and then he entered his plea.
All right, well, let's start with the file that Mr. Butts is here to be arraigned on, that being the file ending in 4478. How does he wish to proceed for arraignment purposes?
Yeah. Mr. Butts would waive the formal reading of the information. He stands mute. We ask the court to enter a plea of not guilty on his behalf.
Thank you. A plea of not guilty will be entered on his behalf.
And then the attorneys went to the next point of this hearing, and that is his attorneys were arguing that charges on 2 of his cases should be thrown out. Follow me. So one of the biggest differences between first-degree criminal conduct and second-degree criminal conduct is penetration. First-degree criminal conduct requires penetration, while second-degree only requires contact. So Jarvis's attorneys are arguing that in the cases ending in 232 and 241, Jarvis is charged with first degree, meaning penetration, but they're saying based on what these alleged victims have said, there was no actual penetration, just touching, and so the first degree criminal conduct charges should be thrown out. I want y'all to know it is really hard to cover anything related to this man and this case. Really hard. Okay, so here is a quick clip of one of his attorneys talking about the case that ends in 232. And for context, this case involves a girl who is now 13 years old, but at the time this incident took place, she was only 4 years old.
She testified that at the time of the incident, she was 4 years old. Her testimony was she was home with Mr. Butts and Mr. Butts' girlfriend. At some point, the girlfriend left the bedroom. Mr. Butts was in the bedroom. She was on the couch. Mr. Butts summoned her to the bedroom, at which point she was ordered to take off her clothes. Her testimony was she took off all her clothes except her underwear. Then Mr. Butts touched her where she peeked. We know from case law, for a CSC 1 to happen, there has to be some form of penetration. Yeah, we don't have any of that. I think to say that there was sufficient evidence on the record that says that there was a penetration for the purpose of a CS1 is an abuse of discretion, and we believe that should be dismissed.
And then the second case where they want this first degree thrown out is for the case ending in 241. And so here's his other attorney arguing why it should be thrown out for that case.
So at the preliminary exam for that instance that was described, the testimony included wearing panties. So again, that is similar. She never described those being removed. She did not describe any instances of penetration and only described light touching while wearing panties. In conclusion, the prosecution did not meet the probable cause standard for first-degree criminal sexual conduct because there was no evidence of penetration.
Now, in response to this motion to have these charges thrown out, the prosecutor argues that both victims indicated that there was penetration. For the first case, the prosecutor says that when the victim said that the touching was happening at the bottom part of where pee comes out, that qualifies as penetration.
When asked what comes out, she stated urine. I then asked, tell me about what part of him touches you there. She states his hand. And what does he do? What does his hand do when he touches you there? She states he rubs my private part with his hands. I then clarified, is this on the top part of is at the bottom. Think about basic anatomy. We know that pee or urine for women comes through the urethral opening. There's a lot of, biological anatomy down there. But we know that the urethral opening is an internal structure that's beyond both the labia majora and the labia minora. She's referring to an internal structure, thereby penetration.
And then regarding the second case, the prosecutor argues that when the victim specified that it was like someone in your ear, that qualifies as penetration.
In the second case, extremely similar. This complaining witness starts off by saying, you know how somebody would play with you in your sleep, like you would feel them in your ear. Or I said, all right, when you wake up to feeling something? She said, yes.
And so after both arguments, the judge agrees with the prosecution. He says that both of their descriptions meet the burden, and so the first-degree charges still stand. Also worth noting, and really hard for me to note, is that based on what the second victim said, it seems like this victim is Jarvis's child.
Moving to the next page, page 84. Question, okay, where were you sleeping? Answer, I was sleeping in the bed with him. Question, you were sleeping in the bed with your dad? Answer, yes.
The trial starts in October. We'll see if I cover it because it pisses me off every time. Bye.